Okay, it's 10:30. Welcome back to session 2 of the zoning track for the Planning and Zoning Conference. And we now have Christopher Bolt, who will be presenting for the next hour and 15 minutes on the ZBA in New Hampshire. Please remember that this session is being recorded. And if you have any questions, please type them into the chat box. We will try to get to them this session, but if not, it will be during the Q&A session later on in the day. So thank you, Chris. How about it?
Thank you, Ken. Good morning, folks. I am Chris Bolt. I'm a partner at Donahue Tucker Chandela out of our Meredith office, and I'm happy to be with you again this year. There are materials that were provided through the OPD that is a shortened version of my prior, far too lengthy treatise on ZBA procedures. That lengthy article is still on my website, which is dtclawyers.com. As of earlier this week, it was on the front page, so you can find it easily. Those materials go into far more detail of the who, where, when, how kind of questions. We'll cover today the big four that you deal with: administrative appeals, special exceptions, variances, and equitable waivers. If there's time, and I'm not sure there will be, we're going to look at some of the amendments to the regulations, the statutes that came into effect of January of last year, but folks I'm finding, are still not as familiar with them as they should be. We may deal with 91A issues, and there are a couple unreported cases that I may call to your attention if we have time. Questions are going to be tough for this section. If you do have questions, raise them in the chat. I will ask Ken at the end of each of the four segments if we have any. Please remember, these are completely to be hypothetical, generic questions, not a particular case that your board is dealing with, because while I see we have a lengthy list and many of you are my firm's clients, many of you are not, and I do not want to give you advice on a case that really needs to come from your attorney. So have it be via the moderator going through the chat. If I'm shocked and we have abundant time at the end, you can raise a hand. But we do, as Ken said, have a separate question and answer session at 2:15 this afternoon. Appeals of administrative decision. Those are governed by the statutes 674.33 and 676.5. That is allowing a person to come before the ZBA if they've been aggrieved by somebody else's decision within the town. But note, it has to be with respect to the zoning ordinance. Why am I... Got it. Sorry, technical difficulties beyond our control. The administrative decision maker, the administrative officer who's made the decision, can be the building inspector. It can be the planning board. It can be the select board if they are the ones that are in charge of issuing building permits or interpreting the zoning ordinance. But it does not include provisions such as discretionary enforcement of the zoning ordinance by the select board, or more importantly, if the planning board has made its interpretation of their subdivision or site plan regulations. Those are outside of your jurisdiction. We have a case now 14 years ago that was pretty clear for the first time of building permits need to be challenged at the ZBA when there is a issue of zoning ordinance interpretation. 2019, the SAE frat house case in Hanover deals with when is there the administrative decision. There, the college had suspended the frat, and the code enforcement officer issued a violation because the ordinance required there to be, if you're going to have this type of living arrangement, it had to be in conjunction with an institutional use. which was the provision of the zoning ordinance. The Supreme Court in this iteration of the case held that the ZBA did an unconstitutional delegation when they gave the sole determining of is this a institutional use over to the college. It was remanded to see if the frat was an institutional use on its own. This case also is good to remember because it has a clear statement of a fairly old principle that lack of prior enforcement does not prohibit current enforcement. And that, as always, you as the ZBA are free to accept or reject evidence as long as the decision is reasonable. And you can reverse yourself. Again, planning board decisions can be the basis of an appeal of administrative decision, but it has to be about the construction, interpretation, or application of the zoning ordinance. Certain provisions of the zoning ordinance, however, might have been adopted with reference to RSA 674-21. Those are innovative land use control provisions. And those are, by their nature and usually by express terms in the zoning ordinance, delegated to the planning board to decide. If it is a 674-21 innovative land use control provision that your voters have adopted and given that authority to the planning board, it's outside the ZBA's jurisdiction. The planning board, however, doesn't need to have completed its consideration of an application for the appeal to the ZBA to be ripe. They have to make the zoning determination. Yes, this is allowed under our zoning ordinance X. Can be made at meeting number 1, but the application, the site plan approval is not approved until meeting number 5. The clock starts ticking on the appeal of administrative decision after that vote on it, meeting number 1. We have a series of cases. Chenard is one of the most recent ones that deals with the definition of junkyard, and their items not being sold commercially were still deemed by the court to violate this junkyard provisions of the zoning ordinance. That's a classic Yankee Yard matter. But we have the Accurate Transport v. Dairy case from 2015 that is still good law, that mere acceptance of the site plan alone is not enough to trigger the appeal to ZBA. There's got to be some interpretation of the zoning ordinance specifically. Timing is governed by 677-15. There's a 30-day appeal period to take the case to the Superior Court. I feel like I jumped some slides. Maybe I did. But it is one of those things where the timing of the case to you is important because your zoning ordinance, or more typically, your ZBA rules of procedure will set forth a time period from which the appeal has to be taken, starting with the date the permit is issued, the permit in question. Most towns have 30 days. Some towns have 45. I unfortunately know of one town that has 65, which is incredibly long. But if there is no set date in your ordinance or in your rules of procedure, the court will interpret it as a reasonable time. And what is kind of like beauty, we know what a reasonable time is not by the case law, and that's 54 days. That was the Tosanovich case of many years ago now, and you had a silent ordinance, a silent set of rules, and the opposing party waited 54 days from the issuance of the permit work had begun, things were up, foundation was in, and the court said, no, you've waited too long. The appeal to the court can come coextensive with the appeal to the ZBA, but with changes to the statute that came into effect about 2016, the court is supposed to stay its action until the ZBA makes its decision. And we do have a relatively new case, came out in April of this year, Newfound Serenity LLC versus the town of Hebron. And that confirms that dual track stay situation to allow the ZBA to take the first crack at the case. An unreported case that I was involved in was the PPI for town of Wyndham, where the Wyndham ZBA sent a matter back to the planning board when they had made a determination based solely on the purpose statements of the ordinance rather than dealing with the merits or lack thereof of the underlying case. That case went up to the Supreme Court by the applicant saying that we did not have grounds, we did not have authority to remand back to the planning board, and the court disagreed with that. That matter is still going on. I believe it is now up to the U.S. Supreme Court in an effort. There are my slides on reasonable time. Sorry, I jumped the gun. But those cases are there. The slides are available to you. If there is a change in the application, there can be a second bite that a butter will have in a case. Harborside v. City of Portsmouth is the second case involving this project. Parade v. Harborside is the first one that we'll talk about in the ZBA variance section. But that case involved a change in the statute for the city's parking regulations. And the applicant had made the initial approval, gotten the initial approval based on I'm going to have X number of condo units, Y square foot of retail space, so many rented apartments, so that there was a list, A, B, and C, of what they were going to do. They realized they had too much retail space and there was potential need for a conference center in downtown Portsmouth. So they went back to the planning board to amend their site plan and said, we now want to add a conference center. But the opponent said, wait a second, the parking regulations have changed. You have to now meet that. And you don't have enough space. The applicant was arguing, hey, we're just here. We've gotten the prior approval. Everything's there. We're grandfathered in under the old parking regulations. And the matter went up to the Supremes after the planning board made its determination. The ZBA agreed with them, and it went on up to the court. And the court reversed, saying, in essence, because the list changed, ABC was the original list, it now becomes A, B, C, and D. You have a new project that needs to comply with the zoning ordinance changes that came into effect between your approvals. I believe the conference center was built elsewhere. One thing to remember, based on the Bartlett v. Manchester case, is every, at least on the variance world, every variance includes a determination of, is the variance needed? And there does not need to have been an appeal of administrative decision brought within in that case, 30 days of the zoning administrative officer saying, you know, you really need to go get a variance for this homeless service center at the back of the church. The church did not contest that decision. They went to get the variance, and they did the original application pro bono, or not pro bono, pro se. They did it on their own, but when they had to go get a variance, they hired an attorney who happens to be on the Supreme Court now. Justice Hans Marconi handled that case, and it is the attorney said, we don't need a variance. This is one where this is an accessory use to a church, where churches always took care of the poor. The ZBA agreed. The neighboring abutters said, you didn't bring the appeal of administrative decision in time, therefore you can't raise it now, therefore you have to get the variance. And the court agreed with the church. That contained within every variance application is a threshold question of whether that variance is actually needed. We've talked on that case already. In the interest of time, I'll speed on. An appeal to the ZBA basically is a stick in the spokes of the project. Things should stop. And that is pursuant to the provisions of 676:6. There is an exception to that rule. If the administrative officer, usually the code enforcement building inspector, says that the project concerns imminent peril to life, threat, health, safety, property, or environment, certain amount of work can proceed. Think of that as the project has started, but you need to button up things to prevent it from becoming whatever, damaging the framing. You're going to weatherproof the outside. You're not going to be able to complete everything else. If drainage structure is started, but because of the flow, it needs to be completed, something like that can happen. Completing the project as a whole is not intended for this. You might have an appeal of administrative decision that raises constitutional challenges. Frequently, these are in the issue of sign issues or validity of the underlying ordinance. Obviously, those are beyond the normal pale of what you're experiencing. Immediately call your town council. Same thing on the issue of municipal estoppel, claiming this other officer said it was okay, it should be okay now. While we have some older cases on that, the Dembiek v. Holderness case expressly stands for the purpose that you as the ZBA don't have jurisdiction for determination of administrative, is there a municipal estoppel issue? That's for the court to consider in a separate action or a combined action. I have one of those pending right now where the applicant was claiming municipal estoppel. The ZBA rightly determined that they didn't have jurisdiction, went up to trial. They didn't do anything about their municipal estoppel claim. The court ruled that the ZBA was completely within its purview to approve what the code enforcement officer had done. And now there's a claim to the Supreme Court claiming that, you know, the court didn't handle it right. And I'm scratching my head going, you didn't ask the court to do anything, buddy. What are you complaining about? So we'll see how that one tracks out. Yeah, and that's again on the Dembiek case, we have the court saying the statute involved doesn't deal with a grant of the equitable doctrine of municipal estoppel, and the prior cases weren't directly on point. I remind folks of the Forster case in part because it is such a good definition of what an accessory use is. Its topic was agritourism, you know, the wedding venue at the farm. That has now become kind of addressed in other ways through statutory changes. But this definition of accessory use is one to remember, because you'll have that come up in appeals of administrative decision. And it must be associated with frequency that is substantial enough to rise above rarity. Back at the time of Forrester, wedding venues on farms may not have been that common. Now I think they more frequently are. But you have to have that frequency that is both commonly, habitually, and of long practice in the local area. So that is one where, just remember this case, triangulate in the background, when you have somebody claiming my expanded use is just an accessory use to what I have already. Sometimes you're asked to give deference to a prior decision of a sister board within your town. The old Willette case stands for the premise that, you are allowed to do a de novo review. You do not have to give deference to the prior board, but you can. It's in essence one where there's flexibility. The CBDA case, for those of you who are on the planning board as well, which is not common, but I remember over the years when we were alive, I'd raise hands on how many folks were on the planning board as well, and sometimes there are. It's the old Fisher v. Dover standard does apply to planning board decisions as well. And just to remember, the Fisher v. Dover rule is that you've got what happened? Sorry. Fisher v. Dover rule says that if there is a denial on an application, the applicant doesn't get to come back and try again for the same application. There has to be a substantial change in the application itself or in the case law. I had one of these in the 2009-2010 timeframe, where the new rules had not yet come into play for variances. My client had been denied a variance for the project was to convert a Victorian into a number of apartments back in the early 1990s. He came back wanting to do it again, came to me in 2008, 2009, and we made the argument that the law had changed so much with Simplex and then BOSHA, if those of you can remember those stage cases. The law had changed, and therefore that was enough for allowing us to come before the provision. And I saw a chat pop up. Is that only case law, or is that change in the zoning ordinance that doesn't allow resubmission? I think if the zoning ordinance changed, you might have a situation where was the variance originally needed, now no longer needed. That's the frequent situation. And that is obviously not barred by Fisher v. Dover. If there's a change in the ordinance that gives, for example, some more leniency, but the variance is still required, you change the setback from 30 feet to 20 feet. And they were denied the 30 feet because they wanted to be 15 feet or 19 feet to the property line. Then the zoning ordinance is now 20 feet. Well, that's not as big a deal as it was when it was 30. That could, in theory, be there. And I apologize to Annie for not seeing your question. How should a ZBA handle when a structure already built, then the owner shows up? I'm going to not answer that one, Annie, because I think that's very close to a case that I have. So let me bow out on that one. You ask Matt Surge, who's the town attorney for you. With that, are there any other questions on special exceptions that are generic and hypothetical? We'll see if any come up later on. Special exceptions. Obviously, they're different from variances. There's a different set of standards available. A variance, the applicant is asking for permission to do something that's not allowed in the zoning ordinance. A special exception is seeking permission to do something that is allowed in the zoning ordinance if certain conditions are met. And they do have to meet all of the conditions. Those conditions should be in the checklist in the zoning ordinance. They can be specific. They can be generic. Generic is a little tougher to try to figure out why you would deny something. Specific can be for things like, okay, the dog kennel is going to have, so much buffer and how many dogs and what lighting and taking care of the natural byproduct of dogs and, whatnot. That might be different from a special exception for, say, a convenience store. You want hours of operation. Will it have a drive-through? If so, where? How much is, what's the sound volume? What's the lighting? Where are the tanks going to go? That kind of thing. So when you're faced with a special exception that isn't a generic and you keep getting requests for the same thing, you may want to interface as zoning board with your planning board on does it make sense to have a change in the zoning ordinance to deal with specific criteria for a specific use. If the conditions are met, there's a checklist A, B, C, D, and E. And if the applicant proves, they have the burden of proof. If they come in with good and sufficient evidence that they meet A, B, C, D, and E, they're supposed to get the variance, the special exception. They are like variances. They run with the land. They're not specific to an owner. But I still note the old Garrison v. Henniker case, which was the explosives plant case in the middle of 1,600 acres, where the court made note of and did not chastise the ZBA for making that variance owner specific because there was clear statements in the record in the notice of decision that the applicant had put on such a great dog and pony show of their safety record and all the extensive protection measures they took for everything from groundwater to trucking to employees, whatnot, that the board rightly had said this variance is specific to you. If you sell the property, if you transfer ownership of, the operation, that new entity has to come back to us. Was that key to the case? No, but it was called out specifically, which made me think we have something that can give us some wiggle room if you need to make specific conditions under very unusual circumstances so that a variance does not just run with the land, variance or special exception. There is a provision now that requires a special exception and a variance to be exercised within 2 years from the date of the vote. That, in essence, is to prevent these zombie approvals that were on books for years and never exercised from outliving the changes to the zoning ordinance. So it has to be exercised. We do not have a case yet, to the best of my knowledge, on what that means. However, I believe it will be viewed much like in the planning board world, what is active and substantial development. It can be you've gotten the building permit, you're starting the site work, you're proceeding with all due diligence. I do not believe it is you have to complete the project within that time. There is a provision that if your project has to go to planning board and that planning board decision is not done early in that 2-year window, you get an additional 6 months. So if it is, you're given an approval on May 11th of 2024, you have until May 11th, 2026 to exercise it, but you have to go through the process of getting planning board approval, and that planning board approval isn't done until March of 2026. You get an additional 6 months from March. So it's not 6 months from May, I believe. It's 6 months from the March to do the to exercise your rights under the approval. Am I right? We'll see if the court takes it up at any time, but I know of no case where it's been challenged. You do have the right to, by the way, to seek an extension of that 2 years. The applicant needs to request that extension for good cause prior to the expiration. Also, there was an amendment in 2018 that allows the zoning ordinance to be amended to deal with those zombie approvals. I don't know of too many towns that have gone through jumping through the hoops to do that, but it is still a statutory provision that if you're seeing things that you have on the books, a number of things prior to August 19th of 2013, which was when the earlier statute that we talked about was put into place, you can go through and work with your attorney to modify your ordinance. And another thing to remember that may not make you popular, but no special exception or variance is required for a co-location or modification of an existing cell tower. Co-location and modification is a statutory provision, federal statutory provision under the Telecommunications Act that is looped in through 12K that says you can go up 20 feet. The existing one can expand 20 feet above its original approved site. So be prepared if folks with pitchforks and torches come against saying that's not allowed, but they can't do that. Well, unfortunately, the legislature said they can. I see one request from Herb for a question. Given the length, Herb, let me get through my materials and hopefully we'll have a chance to answer. ADUs. ADUs were changed in 2017. There is a political football going on right now. House Bill 1291 should put everybody a little bit nervous, both sides of the aisle, because you don't know what's going to happen. That has a hearing before the Senate Commerce Committee this coming Tuesday at 9:30. And that would allow two accessory dwelling units on each lot already allowed for residential use. And one may be detached. It is not that you were supposed to have proof of septic, but that could make significant changes. There's too much detail to go into it for right now, but I just highlight it to those of you who are having to deal with ADU units. This is a game changer to be aware of. House Bill 1291. And since we're about to come into variances, let me look at Herb's question. Special exception must consider the conditions that are codified in the municipal ordinance. Is it correct the ZBA cannot waive? Okay, good point. You cannot waive, meaning you cannot ignore the checklist. If the checklist is A, B, C, D, and E, you can't say to Joe, you'd have to do A, C, and D only. No, everybody has to do all 5. However, There have been cases where you can ask for a variance from one of the provisions, or I think now the better course would be for the applicant to just seek a variance to do what they're wanting to do and argue in part, hey, the criteria says this is an allowed use if I do A, B, C, D, and E. I can't do C because X. Then the ZBA can consider, is there good cause to grant, do they meet the 5 statutory criteria for a variance in light of the language of the zoning ordinance? Because remember, the spirit of the ordinance is one of the elements. And throughout, as we're talking in a minute, the court cases on variance say you look to the language of the ordinance. What is the provision that they're seeking a variance from? Accordingly, it's one where there are old cases that were chastising ZBAs for doing the Joe routine. No, Joe, we don't think you need to meet E and E. No, you've got a checklist. You got to hit all the cylinders. But the 1808 corporation case, I believe, says you can seek a variance from a provision of a special exception checklist. But you have to meet those 5 criteria for that one provision, and then you have to meet all the other ones. Accordingly, I've kind of come around to the idea of it's simpler just to ask for variance in those situations. I think I answered your second part, Herb. Hopefully so. Going into the world of variances, we have the language that we currently have came into effect in 2010. We've been dealing with it for that 14-year period. For those of you, and I loved being in live audiences, and I'd ask the question, how many of you were doing this, were on the board in the 1990s? And every now and then you get a few hands in. Those folks have seen the world change, because the old standard under Governor's Island was you don't get a variance unless you cannot use the property at all in a reasonable manner, at all. Then you got Simplex. Simplex was the decision that created the concept of the constitutional safety valve, that you as a ZBA are the constitutional safety valve between the private property rights of the owner and the police powers of the zoning ordinance to regulate. And there is tension between those two. And the court recognized, look, if we don't have you as a ZBA as a safety valve, allowing somebody to get a variance, we have unconstitutional takings opportunities, and the whole zoning ordinance might be at risk. Accordingly, what we deal with are criteria. It's 674-33. There are 5 criteria. I say I slipped 4 because the first 2 are really combined by the case law. Variance is not going to be contrary to the public interest, and the spirit of the ordinance is observed. Third is substantial justice is done. 4th, values of surrounding property are not diminished. And the 5th is our unnecessary hardship. And that is defined now. Contrary to what BOSHA did, contrary to what Simplex did, we have this definition that we're dealing with. Unnecessary hardship means, 1, owing to special conditions of the property that distinguish it from other properties in the area. 2, there is no fair and substantial relationship between the public purposes of the zoning ordinance provision and the specific application of that provision to the property. And 3, proposed use is reasonable. So when I'm advising a board, or when I'm advising an applicant, because I do represent the forces of darkness, I am on both sides of the aisle, depending upon the community. Hence, I tried to sidestep the earlier question. I say the same thing, though. When we get to unnecessary hardship, we look for 3 things: special conditions, substantial relationship or no substantial relationship for the provision in play, and is the project reasonable? And this applies no matter what. If you were on the board in BOSHA, you remember there is one criteria for an area variance, say the deck is in the side setback, and a second set of criteria if it was a use variance, the convenience store going in the residential zone. We don't have that anymore. We don't have the provisions that say it's necessary for the use. There's no alternative for the use. We don't have, those are BOSHA prongs that are no longer in play. And we come in with, again, a reminder of the Bartlett case that you can be asked, I don't need to be here. Would you make that determination first? Do you agree that I have to have a variance at all for this use in this location? I highlight 4 cases for you. If you haven't read these, or if you haven't read them recently, read them again. Malachi Glen was just cited in a case, albeit unreported, earlier this month. But we'll go through these in a quick succession in the interest of time. Where are we? Come on. Here we go. So the first is Perot. That dealt with a shed that was a foot off the property line, where the abutter on the impacted side had a shed about a foot off the line and didn't care, didn't object. However, the evidence showed that the owner admitted they could put it in a conforming location. It's just not their preference. The ZBA expressed concern about construction and congestion on its lakefront lots. And the applicant had brought forth various allegations of, well, others are in violation, which very much reminded me of my 5 kids, and they would invariably always say, well, you know, Joey gets to do it. Well, that isn't great grounds in ZBA land, especially where the ZBA found, after a series of hearings and some investigation on their own part, the prior violations were either grandfathered, they predated the ordinance, they weren't in violation, or it was the thank you for letting us know that somebody else is in violation so we can go enforce it kind of attitude. The other thing the court considered was the quote unquote cumulative impact provision of the Bacon v. Infield case. For those of you who remember, Bacon v. Infield dealt with a 4x5 foot addition on the back of a lakefront house in Infield to put in a new heating system. That 4x5 foot shed was obviously inside the lake setback because the whole building was inside the lake setback. That was what's called a plurality decision of the Supreme Court. There are 5 justices of the Supreme Court. None of them could agree on why the ruling should be as it is. The original opinion was written by then Chief Justice Broderick, who said the variance didn't meet the 5 criteria. There was a concurring opinion by 2 justices, written by then Justice Duncan, for saying it's important to deny these for the cumulative impact it has on the lake. That was a grounds for it. And then you had 2 that were dissenting, saying it's a 4x5 foot shed on the backside of a house. Come on. Okay. What we have in Perot is the first hint that Bacon's concurrence with that cumulative impact is not good basis, good law. But they assumed without deciding the issue because the applicant didn't challenge the thing. We'll address that later on, and we get a much more clear reading that cumulative impact is not, based on that Bacon decision, is not good law. The next case is Harborside v. Parade. Again, we made comment to that earlier. That dealt with sign variance, and I think I'm going to have to run through some of these to keep us in time. But it was the first decision under the new statute. And the court does a slight swipe to the legislature going, you said you were reviving Simplex and Governor's Island, but guys, you didn't do it quite right. There's differences, but we're going to follow your rule. In dealing with the sign ordinances, they went through the 5 criteria, and that the reason this case is still important is it's one of the few that deal with all 5 criteria. Sometimes you'll have an analysis of only one because that only one is challenged. This gives you a primer on what to be looking at. Public interest, spirit of the ordinance, they say are combined with the same standard, and that standard is, does granting the variance, would it unduly and in a marked degree conflict with the objectives of the ordinance? And this is the stated purpose. What is there? Is the side setback, does it have a stated purpose? If not, I've said for years, the stated purposes are implied to be protection of light, air, privacy, buildings to be separated for fire protection, things of that nature, so that you don't want the houses smack up against each other when you have these side setbacks, unless you're in a downtown urban area, and then you don't have setbacks because that's your zoning ordinance. And you look at the issues by of unduly and in a marked degree by saying, is there going to be a change to the character of the neighborhood, or is there health, safety, and welfare issue created by granting the variance? The example I've used is if you're putting the propane tank within 5 feet of the side setback, that might be a health safety issue. Technically, I've found over the years, propane tanks are supposed to be at least 10 feet away from a property line by internal building code regulations. But one thing to remember, mere conflict with the terms of the zoning ordinance is not sufficient grounds. Think about it, folks. The only reason people are coming to you for a variance is there is a conflict with what they want to do with the ordinance. Accordingly, you can't use that fact, the fact that they don't follow the zoning ordinance, as grounds for denying a variance. They wouldn't be here if they didn't need to be there. And then we talked about the 2 methods of essential character and threat to health, safety, and welfare. The Supreme Court noted that the trial court erred in analyzing the public interest prong by saying, would the signs serve the public interest? And the court recognized that's not the question. The question is, would granting the variance be contrary to the public interest? Mrs. Lowenstein, my 3rd grade English teacher, had us do all those mappings of sentences, and it's important that you have, you know what it's defining, what the sentence structure is there for. You have it in the order. Is it contrary to the public interest? Is the question. Most importantly, the Supreme Court relied on very detailed findings by the ZBA to support its decision. I have said for years, when asked, always give a because statement. I find that it's in the interest, it's within the public, not contrary to the public interest, because, and cite some evidence. I find that it is contrary to the public interest, because, and cite some evidence. You are now required to do that as a result of amendments that came into effect, as I said, in House Bill 1661. You have to have specific findings to support your decision for or against. Used to be only denials. Now it's 4. And if you don't give those, it is grounds for reversal. And we have one case that out of the Housing Appeals Board, so it's the equivalent of trial level court, the 16 Springdale Lane versus Town of Pelham case. And that expressly held, and that was July of last year. To the best of my knowledge, it has not gone up to the Supremes, but the Housing Appeals Board reversed and remanded a provision where the issue was the notice of decision was simply a denial. I see a phrase of the Mahalaki versus Franklin case. That is technically a planning board decision. And that was a decision concerning a solar array where the planning board had simply relied, the pitchforks and torches crowd showed up, didn't want this commercial solar array on 16 acres in the middle of, I want to say 93 acres. And the planning board denied the application because of the general purpose statements at the beginning of the ordinance. And the court said that was not correct. What I don't have that one in front of me, John, and I apologize. I don't recall if it went up on appeal to the ZBA first and they affirmed, or if it went straight up because those provisions were in the site plan regulations. I think it was just a planning board case, but I could be wrong, subject to check. We have the court in Harborside dealing again with various old cases, including Malachi Glen. And on the issue of substantial justice, they restate a classic line that was in Peter Laughlin's treatise for years, still is, that the only guiding rule on this substantial justice prong is that any loss to the individual that's not outgained by a gain to the general public is an injustice. So it's a balancing test. Is there something that is of benefit to the public, the general public, as a result of the denial that outweighs the clear loss to the applicant of that denial from being able to use their property as they wish to do? I think that's going to become more and more an issue because of the court's case, the concurrence opinion that is in the Conway, the Krusik v. Conway short-term rental case. Yes, it's a concurrence, but it's a concurrence of the Chief Justice and Justice Hans Marconi saying when an ordinance is ambiguous, it should be interpreted in favor of the private property rights because the private property rights are constitutionally protected. Will that become the basis of a majority opinion? I can see that court going that way, so I flag it for you, not just in the issue of short-term rental cases, but in statutory or zoning ordinance interpretation cases. That balancing testing especially is in play in a variance. We have the two signs involved, and one of them was a marquee sign on the street level, and one of them was a parapet sign on the top of the building. And one of the things that was considered was the size of this building on this block in downtown Portsmouth that had been approved but not yet built. And the special condition viewed by the court included that to be built principle, that was an allowed building. So this case and the Farrar case that we'll mention in a minute deal with the as-built conditions or the to-be-built conditions that can be the special conditions. So keep that in mind. What's there, what's been approved to be there, can be part of the special condition of the property that distinguish it from others in the neighborhood. This case does distinguish the Bacon case, making note that a concurrence is not precedential, and noting that the complaining hotel, Harborside was a hotel up the street, saying they didn't need that sign to be that big. And the court notes, the applicant's not claiming the size of the sign is unique, but that the property is unique. And so it distinguished what was the issue. And they did not have to show there's no reasonable hardship because they could operate with a smaller sign, because that was part of the old BOSHA standard. And they merely had to show that the sign itself was reasonable. Also that, they're going under this concept. It doesn't meet the spirit of the ordinance and you can get the same results with a smaller sign. BOSHA had the necessity element. You don't have that anymore with the statutory change. Finally, there was an argument by the opposing abutter or opposing hotel. They weren't directly in a butter, but there was no evidence of diminution of surrounding property value. And the court said, look, the applicant's attorney said, nobody's going to be harmed by these signs going up. In part, can you tell what the difference is between, I think this was less than 100 square feet in roughly 1,000 square feet of sign, something like that. And on the parapet sign, the ones on top of the building was even less. So the concept was, can you tell the difference in size from that distance, really? It's for the ZBA to resolve conflicts of the evidence. You, as a quasi-judicial body, meaning you apply facts to law, are like a judge, entitled to weigh evidence, believe who you want to believe, but you got to have a rational basis for it. And the expert can be there and can be believed. If you're going to not believe the expert, my advice is at least have a contrary expert that has been brought in to review that expert. And keep in mind, the statutes clearly allow the boards to require third-party review to be paid for by the applicant. If you come in and with a hydrogeologist saying this is not going to have negative impact on wetlands flow and we're going to treat the stormwater this way, well, you can have your town engineer review that report, agree, make comments for changes, whatnot, and that nickel is paid by the applicant. I do note that one of the provisions of House Bill 1661 was to require all fees to be posted, required fees to be posted on your website. And if it's not, you can't charge them. So I have advised boards to add at the bottom a line, the equivalent of charges for third-party review, including attorney review, may be charged at the amount incurred. So there is some flag because you don't know what it's going to be. You don't know if the case is going to need it. But have that caveat on your fee list and remember to post it on your website and at town hall. But going back, the ZBA gets to rely on its own knowledge, experience, and observation of the area. That was a concept in Malachi Glen as well, but you couldn't just say, the zoning ordinance says we have to be 50 feet from the water and nothing else. It's like, well, that's not what's allowed. And we're getting into Malachi Glen right now. It is an old case, but as I said, it was cited in a decision earlier this month. This was a case it was on Route 4. It was a multi-unit self-storage facility. I want to say 100 units. It was approved in the 1990s. The bust hits. They don't build it. They come back in the early 2000s and want to get the site plan approved. Modified rather. And the town had implemented a wetlands buffer ordinance that impacted this property. And the ZBA grants the variance needed for the driveway, but refused the variance for roughly half of the units because it would be within the buffer zone. And part of the rationale was our voters just voted this, we have to implement it as it's been implemented. Despite the fact that the applicant had come in with a noted geologist, hydrologist saying, we're doing all of this stormwater management control to capture the water, filter the water. It's better than if the site was left as it is. Words to that effect. Staff didn't have heartburn with the application. None of the abutters had heartburn with the application. There was no evidence against that expert. None. Not even an abutter saying, I don't believe that it's going to impact my whatever. Here, the court said the uncontroverted evidence on the surrounding issues and the protections of the wetland were contrary to the ZBA's decision, and therefore the ZBA's decision was not reasonable. Remember, when you're challenged, the court looks, is your decision lawful and reasonable? And you're given a deference. You're given a deferential treatment. Your findings of fact are deemed prima facie deemed lawful and reasonable, unless there is evidence to the contrary. The Supreme Court found that the board's decision in this case violated that standard. It was not allowed prima facie lawful and reasonable because of the weight of the evidence of the expert that was uncontradicted. It was deemed, it makes reference to the old Vigent decision that a use is deemed reasonable if it is allowed in the zone. And you as the ZBA are not allowed to kind of redesign or change the use in your determination. You take the application as it comes. They want to put the deck where they're wanting to put it. Does it meet the 5 criteria? You might be able to suggest, well, if it was 2 feet shorter, I wouldn't have the heartburn because it gives enough space between X and Y. If the applicant wants to amend, great. But it's not you don't deny it based on their lack of change. You're denying it based on whatever your because statements that you come up with, that it's too close to X and Y because. In this case, it was under the BOSHA, so I'm just flagging that financial hardship prong as technically no longer part of the mix. Farrar v. Keene is a case involving a honkin' big Victorian 7,000 square foot house downtown Keene in a district that allowed both residential use and office use. The only reason this applicant was in front of the ZBA was because the zoning ordinance was silent on a mixed. He wanted 2 units in the house, one of them for him to live in, and the rest to be offices. Buildings on either side of the street were either all offices or all apartments. Nobody was a single family home on that street. The objecting abutter was on the backside in a different zone, separated by a pretty big fence. And the issues come in to say, what are the special conditions of the property? And the court noted the size of the lot and the size of the house, the allowed uses, and the evidence that was before the ZBA that having it all offices would have a higher traffic count than if there was this mixed. The ZBA could reasonably find that although the property could be converted to one or the other, it was a reasonable use to allow the mixed. We go through, in that case, the third prong, which was still the Boscia test. But this case does note the test for substantial justice that we discussed previously. Rarely will you see, but occasionally you might see a disability variance. That is expressly allowed under 674-33-5, which allows an applicant to not have to prove unnecessary hardship when the issue is a reasonable accommodation necessary to allow a person with a recognized disability to reside or regularly use the premises. Think of this as the wheelchair ramp. Okay. Wheelchair ramps have to come within certain distances of driveways. Driveways can frequently be in setbacks, but you need to get the ramp from the driveway to the door. I have had one where the applicant was building units specifically to be ADA compliant. And therefore, it wasn't for an individual person. This isn't your mother-in-law coming into the unit. It's, I'm creating housing for this population. And that is allowed under this provision. If it is for a specific person, it can be tied to that person's residency or regular use of the property. For, if it's mom coming in, the ZBA can say, okay, will you take it out when mom's no longer there, and have that be a condition. I haven't seen too many of those because sometimes that ramp is needed for the next generation of us. So just think about it. They're very uncommon, but it is one where when you're faced with them, let me know, or let your attorney know. John, you're asking, is it okay to grant regular variance when only asked to grant disability one? I would stay with the application. If the applicant's coming in asking for a disability variance, you can't grant the general variance without finding unnecessary hardship. You can grant the disability variance without finding unnecessary hardship. So if the applicant's coming in for a disability variance, my suggestion is grant the disability variance. Okay. Any other questions on variances? We do not have time. My apologies. We're going to run through equitable waivers. Equitable waivers are governed by a separate statute, 674-33A. It is only for physical layout issues. It is not for use restrictions. Schroeder case dealt with particular zoning ordinance, wetland buffer language that prohibited uses in that area, not creating a setback type of issue, created prohibited uses. And the court said an equitable waiver could not be granted for that. The owner has 4 criteria to meet. Basically, that the violation wasn't noticed in time, that it is not based on ignorance or willful, you know, I'm not going to look at that ordinance, so I'm not going to know about its provisions kind of thing. But it can be on a good faith error of a town personnel. The town comes out and the code enforcement officer says, yep, that foundation looks right. You can go ahead and pour, and it comes in to be 6 inches too close or a foot too close or whatever. That can be a good faith error. The physical violation does not create a public or private nuisance or diminish the surrounding property values of the adjacent affected property. And the degree of work is such that ripping it out costs too much in light of what the benefit would be. You have also a 10-year rule. If the violation has existed for 10 years and there's no enforcement action, no letter in the file to the owner or prior owner, then you don't have to meet the first 2 criteria. You only have to meet no nuisance, no diminution of surrounding property value, and the cost element. Contrary to special exceptions and variances, this statute expressly says that if it gets an equitable waiver, it's not a non-conforming use. Doesn't trigger it into a non-conforming category, but you still have to comply in the future. It also, the case law is, it doesn't waive the owner's obligation to be knowledgeable of the applicable requirements. This is truly a whoops rule. There is an unreported decision called 3JX decision where the Supremes reversed a grant of an equitable waiver where it was not based on the owner's error, but a conscious decision. Yeah, I knew I was too close. I put it in there. That doesn't qualify for an equitable waiver. It may qualify for variance after the fact, but it doesn't qualify for an equitable waiver. We have really only one reported case on equitable waiver statute, and that is the Dietz v. Tufton Borough. And I will try to rocket through this, but in short, there was a lot of prior approvals associated with this lakefront house in Tufton Borough. And unfortunately, the applicant had an abutter from hell, and they were very irate that the last approval had been granted. And basically then dug through the file and find that, hey, wait a second, one of these approvals was wrong. It shouldn't have been granted. And that means that their whole thing has to be torn down. And the board went, that's a little harsh. Let's see here. And they went through the equitable waiver criteria and found that they can meet it. The abutter was saying you didn't make findings of fact on each of the elements. And this was prior to 1661. The court in the Dietz case, because it was 2019, said written findings on each element are not required. Now they are. I would suggest you find on equitable waiver, each of the prongs have been met because XYZ. It also noted that this rule is to be interpreted broadly when it's on reliance of a mistake by the municipal rep. You're here to not penalize somebody that got the approval that they thought they needed and built it. The burden of proof is on the applicant to show that they meet those four, or if it's been in existence for 10 years, the last two. But once the ZBA grants, the burden of proof is to the appealing party, always, no matter which element, which of the four cases we've been talking about. The burden of proof is on the appealing party to show that there's an error of law or that the decision is unreasonable. Confirms that ZBA members are to use their own knowledge. Variance is not a prerequisite to getting an equitable waiver. And this one clearly put the kibosh on the concurrent opinion of Bacon, expressly saying it does not extend. The cumulative impact rule does not extend to equitable waivers. I believe they did it in such strong language that cumulative impact doesn't apply, period. Find another reason. Quickly on 91A, please, email is not your friend. It is truly one of those things. You and I deal with it in our daily lives. Is the only means of communication. Do not use email to communicate on a case. There are two times you get to use it. Your administrative assistant, your planner, whoever sets up the meetings is sending an email out to all of the boards saying, can you meet on X date? You respond, not reply all. If I was omnipotent ruler of all I surveyed, I would move the reply all button to the far right of the Outlook bar, so you couldn't accidentally hit it. You only can hit reply. You have to do a physical act to get over to reply all. Reply only to the administrative assistant. Yes, I can. No, I can't. Do not discuss a case. Materials can be sent to you. Don't respond other than I got it to the administrative assistant. Okay. The reason is you're not allowed to have discussions outside of a public meeting. It doesn't have to be a public hearing, but it has to be a public meeting unless you qualify for one of the criteria for a non-public session under 91A:3, Roman 2, which are very narrow and very rare for a ZBA to have to go into. You can go into what's called a non-meeting so long as you have your lawyer either on the phone, on Zoom, or in the room having a meeting to discuss, just like you would if you're going into your private attorney's office. That's under 91A:2, 1B. Set those up through the administrative assistant in the chair with your attorney. But again, those are fairly rare. You can consider in a non-public session written or oral legal advice, but you have to have been in a public meeting, properly go into a non-public session by roll call vote for the express stated purpose, be in the non-public session with rudimentary minutes at the very least, come out of non-public with a stated time, seal the minutes. If you're reviewing my legal opinion, you seal those minutes so that my legal opinion does not become public. And you then add those minutes, make a note with the clerk's office, because we now have an obligation to list out all sealed minutes and review them at least every 10 years. Do they still need to be sealed? A lot of heartache to go into a non-public session. Better to have a non-meeting with your lawyer so you can ask questions, hear answers, and not discuss and decide a case, but what do we have to do here, Chris? You know, what are the issues we have to be aware of?
Chris, we are now
Out of time.
over time. Do you have any final things you need to say?
Talked about that. My apologies, folks. do look at 1661. And remember, findings have to be included in your notices of decision, use because statements. Come back to us at the 2:15 session, and thank you and have a lovely lunch. And I appreciate you sharing this glorious May Day with me. All the best.
Thank you all. Thank you, especially Chris. I'm just gonna, there we go.
Yeah, there we go.
So we will be actually closing out this morning's session, and we will have to start up because of software capabilities. We will be starting a new webinar essentially for the afternoon. You'll need to rejoin through the same link that you used before. And so we will be back at 12:45 with the session on enforcing board decisions. So thank you, and we'll see you at 12:45.